Hey again, David Phillips, attorney. The question's been asked, do I need to reaffirm on my debt with the creditor in a Chapter 7 case? Generally, we would be talking about an automobile. The answer to the question would be, it depends upon the creditor. Most people don't understand that the reaffirmation is actually at the initiation of the creditor. The debtor can certainly request that and indicate to the creditor that they wish to reaffirm the obligation and keep paying the debt. But the creditor is who prepares the reaffirmation and agrees to enter into a reaffirmation with the person filing bankruptcy, not the other way around. In most cases, the creditor will more than be happy to file a reaffirmation agreement with the debt you're talking about, because that obligates you to pay that debt again, whatever the current balance is. Normally the terms don't change, meaning the interest rate, monthly payment, everything is just like it was before you filed bankruptcy. So in many cases the creditor's more than happy to do that, because that protects them from eventually the discharge that would come in the Chapter 7 case. And most cases they do not want the vehicle back in our example of a car creditor. So it's very important to know the circumstances in your particular case. But if you have to have the vehicle, then generally a reaffirmation agreement would be necessary, and that effectively removes that obligation and debt from bankruptcy protection and eventually the discharge. From a bankruptcy lawyer perspective, we generally don't like reaffirmation agreements, because that defeats the purpose of the Chapter 7 bankruptcy, which was to get rid of debt. But I more than understand that you may need a vehicle to get to work, things like that. So we do see car reaffirmations practically every day. So it's not unusual, but I would want you to be very sure that it is an obligation that you feel like you can afford to keep. And usually it's worth at least asking for better terms from the creditor, maybe a lowering of the interest rate, a lowering of the monthly payment, before you actually enter into the agreement. The reaffirmation agreement must be filed with the bankruptcy court before your discharge is entered. If it's filed after the discharge comes in, it's too late and it would not be effective. And there are a few car creditors that do not even request that you sign a reaffirmation. That depends. We just have to wait and see who your particular creditor may be. In the past, Toyota Motor Credit was pretty good about not requesting a reaff. And these are generally cases where you're a good credit risk, you've always made your payments, and they, for a business decision, just decide it's not worth fooling with all of the paperwork in order to get a reaffirmation agreement filed with the court. But most of your major car creditors do request a reaffirmation agreement, and it has to again be filed with the court before the discharge. So you have a fairly short window of around 90 days from the time the case is filed to get that reaffirmation negotiated with the creditor and filed with the court. If you didn't get that done in time, theoretically the car may go back to the creditor if they refuse to accept your funds and your payments after the discharge goes down. But anyway, that would be the way to look at reaffirmations. Prefer you probably did not enter into one unless you absolutely have to, and that way again you would hopefully get rid of even more debt. Even though if you keep the car under what we call retain and pay, meaning there is no reaffirmation, the creditor still has a lien against the vehicle, and they could pick it up at any time if you fail to make the payments. However, they wouldn't be able to come after you for the debt that you reaffirmed on if you did, because without a reaffirmation, the debt that you owe on the vehicle is discharged along with all your other debts. It's just, again, that they retain that lien. Hope that gives you some good information about reaffirmations. Please call our offices if you have a question about that. I don't mind at all answering the question if I can. If you prefer to contact us by email, just go to phillipsbankruptcy.com, go over to the contact section, send me an email, and we'll see if we can't get you an answer very quickly. Thanks for watching.